Let's focus on the part of the Bill of Rights that actually protects the rights of accused individuals, of accused criminals. So there are four amendments within the first 10 that predominantly protect the rights of accused individuals in the United States. And that's the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, and the Eighth Amendment. Super important that you keep these amendments straight because there's lots of questions that can be asked of you regarding them. So let's do the Fourth Amendment first. So the Fourth Amendment largely protects against unlawful searches and seizures by law enforcement. It basically governs the actions of like law enforcement and what they can and can't do in terms of either searching the property owned by an individual or searching an actual like person. So basically, the process works in the United States as follows. In most cases, law enforcement, if they have a suspicion about criminal misconduct and they want to search a residence or an individual or whatever the case may be, they need to basically go to a judge and obtain a search warrant. And we've all seen enough like movies and TV shows where you see law enforcement basically announce they have a search warrant and then enter like a place to search. The way that you get a search warrant is you go to a judge, you basically explain like why you need to be able to search like property, establish probable cause, right? You show that there's good reason, and then the judge determines whether or not there's enough probable cause to issue the search warrant or not. In many cases, right, a good criminal defense attorney, if a search warrant wasn't properly obtained, could potentially have evidence that was seized at a crime scene disqualified at trial. It's not one of the mandatory cases that you need to know, but the rule itself could appear on the AP tests. And frankly, I'm surprised this isn't one of the mandatory cases you need to know this year. Mapp v. Ohio in 1961 established what's called the exclusionary rule. And again, this is kind of what I just said that evidence can be disqualified at trial if law enforcement don't go about getting it in the right way. So when evidence is entered in a trial, defense attorneys can like challenge it, and then the judge could potentially determine that again, like procedure wasn't followed. And let's say you have a murder weapon with the defendant's fingerprints on it, but law enforcement doesn't go about getting it in the right way. And a defense attorney successfully challenges the admission of that evidence in trial. A judge might say, yeah, even though this is like really compelling evidence, like it was obtained in a wrong way, and disqualify it, exclude it from being used at trial, and then the jury never even knows that was found. So that's why it's super important that law enforcement, especially those that are on a crime scene initially, really are obtaining evidence in the right way. The Fifth Amendment deals with a couple things. It definitely relates to double jeopardy. So, double jeopardy is the idea that you can't be tried for the same crime twice. So, bottom line is the prosecution, like the government, really has one chance to bring you to trial and convict you of a particular crime. And if a defendant is found not guilty, you can't be charged immediately again and tried for that same crime. So it obviously works in favor of the accused in this country. If you are found guilty, and for example, evidence pops up years later that exonerates you, you could have another trial and essentially be released at that point. But if you are put on trial and found not guilty, you don't have to live in fear of having that same charge come against you at a later date. So it's really important that the prosecution only brings charges against you if they feel like the evidence is going to lead to a conviction. Also, the Fifth Amendment protects against self incrimination. If you are being accused of a crime and it's your trial, you can't be forced to testify in your own trial. Again, this is a fundamental right that you have as an American citizen. If you are a defendant, or if a defendant does claim the Fifth Amendment, we often hear this like, I plead the Fifth, meaning like I'm not going to talk. If a defendant does plead the Fifth, a jury is always going to be instructed by a judge in a case that that's their constitutional right, and that shouldn't be held against them when a verdict is being decided. It also prevents what's called unfair eminent domain. Eminent domain is when the government seizes your property because there's a compelling reason to do that. So like we need to expand a highway, or we need your property as the government for some reason. They can't just take it. The Fifth Amendment requires that there is a fair process that is like basically gone through, and then you have to be compensated fair market value for the value of your property. So if the government takes your land for some reason because they need it for an official purpose, ultimately they have to provide you with fair compensation, right? So this just prevents from unfair eminent domain, and eminent domain is when the government needs to seize your property because there's some reason, some need to do that. The Sixth Amendment deals with some of your basic trial rights. So, for example, the biggest one is that you have a right to an attorney, right? We've all heard your basic rights, read in, again, a crime show or a TV show, a movie, that one of the first things you're told is you have a right to an attorney. So, in this country, you have the right to legal counsel. And if you, for some reason, are financially not able to provide one for yourself, the government is required to give you one, right? So, you have the right to a lawyer. Also, you have the right to a speedy trial. This basically just means that if you're accused of a crime, you shouldn't have to spend 10 years in jail waiting for your trial. That within a relatively reasonable amount of time, that you actually have like your day in court. You have a right to an impartial jury, right? So you have a right to a jury that's not already going to be biased against you. There are pretty extreme examples of high profile crimes. Like you're normally tried by a jury of your peers. So if you commit the crime in Montgomery County, for example, your trial will be held in Montgomery County, and residents of Montgomery County would be in the jury. The only exception for this would be if a defense attorney files a motion basically saying that there's really no way to get a fair trial because everybody in that community or that area is like already knows a lot about the case, and they may have already come to some sort of like determination even before hearing evidence that you're guilty. So you could always ask a judge to have the case moved to another vicinity. And you also have the ability to confront witnesses against you. So if an individual is testifying against you, your lawyers have a right to cross-examine those witnesses and to poke holes in like their testimony. So again, you have the right to confront anybody that's testifying against you. And then the Eighth Amendment protects against a couple things as well. The most popular thing we usually talk about with the Eighth Amendment is that it prohibits cruel and unusual punishment. Obviously, that's up for interpretation, and that's sometimes where the courts get involved. But in this country, this prohibits you from being exposed to cruel and unusual punishment. So, like, some of the biggest debates we've had in American history are, like, for example, does the death penalty, right, constitute cruel and unusual punishment? The Supreme Court's interpretation on the Eighth Amendment is that the death penalty does not violate the part of the Eighth Amendment that deals with cruel and unusual punishment. That if you execute youth, right, like under the age of 18, they do consider that to be cruel and unusual. If you execute people that are deemed to be mentally ill at trial, that would be considered cruel and unusual punishment. But otherwise, right, a standard sort of execution, a death penalty sentence in a state that allows it is permitted. Again, it's a state by state decision. We've talked about this already, that it's up to the states to decide if they want to implement the death penalty or not. And many have chosen not to. But the federal government the Supreme Court has ruled that the Eighth Amendment does not prohibit it. Also, it deals with things like excessive bail and excessive fines. So, for example, if you are being held on a relatively minor, suspicion of committing a crime, your bail can't be set at some astronomical amount, right? Or if you are convicted of shoplifting a loaf of bread from a convenience store or a supermarket, you can't be hit with like a $10 million fine, right? Again, this just deals with like the punishment that the criminal justice system gives, and then it can't be overtly cruel or unusual.